So imagine letting an employee go, right? You hand them a standard 8-week severance package, but then a judge looks at your company's vacation policy and suddenly orders you to pay them for 2 full years instead.
Yeah, I mean, it sounds like a bizarre clerical error, but in the world of Ontario employment law right now, it's a very harsh reality.
Right. And that is exactly why we're doing this deep dive today. We're looking at a really fascinating HTW law article on how employment contracts in 2026 have just, well, fundamentally changed.
They really have. Whether you're an employee trying to understand your actual rights or an employer trying not to accidentally bankrupt your business, you kind of need to understand this shift.
Because, yeah, a single innocent-sounding workplace policy can literally unravel your entire legal protection. And the perfect example of this unraveling actually starts with something pretty basic, right? Vacation time.
Exactly.
Oh.
Specifically, how the Ontario Employment Standards Act, the ESA, views vacation as 2 entirely separate legal rights.
Which, you know, usually trips people up because we just think of PTO as one single bucket.
Right, but legally, you have the actual physical time off, so the 2 to 3 weeks you spend resting, and then you have the vacation pay.
And that pay is a strict deferred compensation formula, right?
Yeah.
Like it has to be exactly 4 or 6% of your gross wages, depending on your tenure.
Spot on. It's a hard mathematical rule.
Okay, but let's unpack this for a second. Let's say I'm an employer, and my employee just doesn't want to take the time off. They're a total workaholic. Can I just say, well, fine, keep working, I'll pay you the cash equivalent?
You really can't. And this raises a super important question. The ESA statutory minimums are legally untouchable.
Wait, really? So you can't just buy them out?
No, absolutely not. If an employee won't take their time off, the employer actually has to force block scheduling.
Wow, okay.
Yeah, you can never apply a use it or lose it forfeiture rule to those statutory minimums.
Yeah.
You can only forfeit extra vacation time that actually goes beyond the legal baseline.
So if a company writes a lazy employee handbook that just generally says all unused vacation is forfeited at the end of the year, they've just written an illegal policy.
Exactly, because it accidentally includes those untouchable legal minimums. And here is where the dominoes fall.
Oh, boy.
Right? Under a legal precedent known as the Waksdale Doctrine, courts view an employment contract as a single, indivisible ecosystem.
Kind of like a Jenga tower, then.
Precisely like a Jenga tower. Because that generic vacation policy violates the law, it doesn't just invalidate the vacation section, it reaches across the contract and voids entirely unrelated sections.
Which means it voids the termination clause.
Exactly. It voids the termination clause.
Here's where it gets really interesting because, wait, a bad vacation policy magically rewrites how someone gets fired.
It does. Without a valid termination clause, employers lose the protection of the standard 8-week statutory severance cap.
So they get pushed into common law reasonable notice. And for you listening, common law basically means a judge decides what's fair based on historical factors, which can lead and reach up to 24 months of pay per employee.
Yeah, up to 24 months. And what's fascinating here is companies used to have a safety net for this.
Right. They'd put a saving provision at the very end of the contract, like a generic Band-Aid stating, well, if anything in here is illegal, we'll just default to the ESA minimums.
But a massive 2025 ruling, Baker versus Van Dolder, completely killed that safety net. You can't just slap a generic legal disclaimer on a poorly drafted contract anymore to save it.
So the safety nets are gone, which means we have to look really, really closely at the actual text of these agreements. The source highlights some recent rulings that show just how hyper-literal courts are getting now.
Yeah, like the Brocklehurst case. That case is a masterclass in why precision matters. In Brocklehurst, a single missing comma changed the grammatical interpretation of a sentence enough to void the entire termination limit.
A single comma. That is wild.
It is. And it all comes back to a principle called contra proferentum. That essentially means that if there is any ambiguity in a contract, courts will interpret it in favor of the employee, not the employer who drafted it.
Which totally explains why unlimited PTO policies are suddenly such a massive trap. I know a lot of startups love offering unlimited vacation as this cool tech bro perk.
But if you aren't tracking exactly how many days someone takes off,
you have no mathematical way to prove you paid them that required 4 to 6% statutory minimum.
Exactly. You've essentially created an undocumented liability. If you can't prove compliance, courts assume you aren't compliant.
It's just crazy. The very things designed to be modern and flexible are becoming the biggest liabilities. And it's not just old school things like vacation days either.
Right. Brand new tech is creating massive legal ambiguity too. Take artificial intelligence, for example.
Right, like if an employee is using company time to engineer AI prompts, who actually owns that intellectual property?
Well, contracts must now have explicit, exclusionary language assigning AI prompt IP directly to the company. Otherwise, you risk severe data leaks and IP disputes because, again, ambiguity always favors the employee.
Always. So if there's a core takeaway for you here, it's that broad, standard, one-size-fits-all contract language is basically dead.
Completely dead.
Yeah.
In 2026, hyper-specific drafting is your only shield against massive liability.
Yeah, you have to proactively audit your entire employment architecture. Literally every policy, every comma.
They really do.
Which honestly leaves you with something fascinating to mull over. If a single missing comma or, a poorly defined AI prompt policy can invalidate an entire contract and bankrupt a company...
It's a scary thought.
It really is. Like, are we heading toward an era where corporate legal agreements have to be entirely written and audited by AI just to ensure human grammatical errors don't accidentally trigger a multi-million-dollar Jenga collapse? Definitely something to think about next time you sign on the dotted line.